I'd like to begin by revisiting the Abdul Muttalib case and attempting to clarify some issues that have been subject to a lot of controversy, both in the press and the public and on the Hill. Some of those controversies stem from confusion or lack of or misunderstanding, perhaps, about how you proceeded on the day that Abdul Muttalib was arrested and whether the intelligence community was consulted about the handling of the case. So, Mr. Director, can you walk us through the basics of what occurred on Christmas Day and how you interacted with the intelligence community, almost a chronology?
Yes, well, starting around noon, a word was received, and again, I'm not specific on the particular time, so please don't hold me to those, but approximately around noon, a little bit afterwards, we received word that an individual on a plane inbound to Detroit, I believe from Amsterdam, had apparently attempted to set off something. The initial reports indicated that may have been firecrackers. When the plane landed, first on the scene were those at the airport, principally Customs Border Patrol, ICE agents. We were shortly there ourselves and learned that an individual had attempted to trigger an explosive device on the plane and had been stopped by one or more passengers. He was placed into the custody of I believe it was Customs Border Patrol, and because the device, as he attempted to ignite it, had burned him, he was taken in custody to the hospital. As we found out about that, we immediately attempted and did find out information about him, understood that he was Nigerian background, had flown in from Amsterdam, and immediately emails, traffic began from both Detroit to our National Joint Terrorism Task Force here in Washington, and thereby out to various agencies, Department of Homeland Security, NCTC, and the intelligence community about what little information we had, and that correspondence carried through the afternoon. Approximately 2 o'clock, a little bit before, a little bit afterwards, our agents went to the hospital and determined to try to interview Abdul Muttalib with the specific objective of finding out whether there was any immediate threat of additional bombs on other planes or additional persons on that plane who might constitute a threat, and spent up to an hour interviewing Abdul Muttalib. As has been pointed out, determination was made not to provide Miranda warnings on the belief that this was information that was absolutely essential to determine public safety, and so that interview was conducted along those lines. We continued to obtain information from various entities in the intelligence community throughout the afternoon, and at 5 o'clock that evening there was a video teleconference that was established by by John Brennan at the National Security Council. Attended on that video teleconference were most of the members of the intelligence community, and through representatives of the Department of Justice, National NCTC, National Security Council, and of course representatives of the FBI to review what had happened and what was going to happen thereafter. There was the ongoing assumption at that time that Abdul Muttalib, having been arrested on the United States soil, would proceed through the Article 3 processes. There was no debate at that time, nor there was the issue of whether or not to Mirandize him raised in the context of that discussion that afternoon. Later that night, it was determined to try again to interview Abdul Muttalib, and at that time it was determined both with the Department of Justice and the FBI that we would follow our ordinary procedures and attempt to interview him and provide him his Miranda warnings. When the agents went in that evening, he was less responsive to interviewing. He was not providing information, basic booking information. He was read his Miranda rights and discontinued any conversation afterwards. He remained in custody in the hospital that night and was brought before the magistrate the following day and was presented before the magistrate, as is required under Rule 5, the Federal Rules of Criminal Procedure, later on the following day. That, in brief overview, is what happened on that day. It was consistent with the practices that we have utilized generally throughout any arrests that we do in the United States.
Was there communication with the intelligence community about how this case to be handled? Was there cooperation among the various law enforcement agencies and intelligence agencies during this process?
Well, there was continuous coordination and obtaining of information to the extent that we could pull it from our various archives that afternoon of Christmas. And the communication was on between persons not at the highest level. In other words, the ODNI would have been not necessarily involved in that communication, nor the Secretary Napolitano, nor the Attorney General. But yes, in the discussions throughout that afternoon, there was a colloquy between various elements of the intelligence community and the law enforcement community as the events unfolded.
Were his arrest and the process that you just described handled any differently than any other terrorist suspect may or may not have been handled any differently? Any other suspect arrested in the United States either before or after 9/11?
The only distinction I'd say is that we made the determination early on not to Mirandize him in the initial interview. We knew he had a relatively short window of time in order to conduct that interview, and believed that in that window of time we had to focus on immediate information relating to public security.
You indicated that the next day the suspect was taken before a magistrate?
Yes, we're required under the rules to present the individual in custody before the magistrate. Generally, we're required to do it within a 24-hour period. Is there a Mirandizing requirement at that time? That happens. Whenever you're presented to the magistrate will review your rights for you. And it was done on that occasion. At least that's my understanding.
So the court itself would advise the defendant
yes.
of Miranda rights at that time. So really there's a requirement, I mean, listening to your testimony, that except for the public safety aspect of this, a suspect arrested in the United States would be subject to Mirandizing under the law.
Yes, once that person has been presented to the magistrate in the initial appearance.
There's been considerable discussion about Miranda warnings and how it may or may not impact suspects from cooperating with investigators. I'd like to just explore that a bit with you. Given that a suspect is going to be advised of his rights by a court within hours after his or her arrest, the FBI, is it correct, generally provides Miranda warnings itself so that you can take full advantage of anything he might say in the intervening period, and preserve it for an Article III court. I mean, many people have contended, however, that the moment a suspect is provided Miranda warnings, he'll immediately cease cooperating with you. And so I'm asking, in your experience, is it the case that suspects become uncooperative and invoke their right to remain silent after being read Miranda rights, and does that attitude persist? Just your experience.
Let me divide that up into two parts if I could. The first part with regard to our policy. We make hundreds of arrests a day across the country. State and local law enforcement make thousands of arrests across the country daily. It is generally the protocols for ourselves as well as state and local law enforcement that you provide Miranda warnings before interrogating somebody who is in custody to maximize the opportunity for utilizing whatever is said by that individual in the case against him in court. Turning to the second part of that in terms of what one can anticipate, it really depends on the case.